Hello, everybody. My name is Juan Carlos Brando. Thank you so much for having me today in this show with one of the attorneys in the law firm of Margaret W. Wong and Associates, the law firm that has been there for over 46 years, starting in 1977, and working for you and for your immigration needs. So, if you have any questions today, please feel free to send them live. We're going to be answering the questions live with the attorney Noor Chamas, who is one of the experts, attorneys in the law firm working and helping a lot of people in the asylum cases, cancellations of removal, litigation, court. Well, this is the attorney that you need to talk in order to represent you in the court. Let's welcome the attorney. Hello, Attorney Noor. Thank you so much for having me today, and good afternoon.
Good afternoon to you. Thank you for having me.
Thank you so much. Attorney, I would like to start by talking about uh, the situation in the United States related to the asylum. I've heard that there are some changes, some specific changes and substantial changes that are coming to the asylum applications or to the process of the asylum. So, what can you tell the people about this process? What is changing? Is it positive or is it negative?
Yes, for sure. So, in terms of the process of filing asylum, there's some changes that are being made now. So, certain asylum applications are being able to be filed electronically. Those are usually affirmative applications where the person is not in removal proceedings. And then there's certain other categories that qualify. But essentially, what they're trying to do is sort of reduce the mail backlog, because what's been happening is people have been filing for asylum and you're not even getting a receipt notice until about a month and a half later, because they're so backlogged. And so even checking the asylum application preliminarily has been taking a long time. So now they're allowing some of these applications to be filed electronically. When you file electronically, you can actually get a receipt notice pretty quickly. And then that also, frees up some of the mail asylum applications so that they don't have such a backlog, and they can issue receipt notices for those applications more quickly. I think overall it's a positive development. I do believe that hopefully we can move more towards electronic filing because it makes things a lot easier. You can get an immediate receipt notice. You don't have to wait, especially when you're dealing sometimes with court deadlines and having to file certain things with the court, but you're waiting for an asylum application receipt that's taking forever to get to you. So hopefully this trend continues, but I think this would be a positive development.
Thank you so much, Attorney Noor. And one more question about this is about the probatory. Well, not probatory, is the burden of the proof. If I don't know if
Sure.
I'm using it correctly
Mhm.
terms, but when you file for asylum now, what do you do to prove that you need to be a asylee in the United States of America? What do you need to prove?
So essentially, when you're filing for asylum, you're asking the United States to provide you protection because you are afraid to return to your home country. Now, what does that mean? When I ask clients a lot of times, are you afraid to return? Sometimes they don't fully understand. They tell me, well, I'm afraid because the economic situation is difficult. I can't find a job, but that's not what asylum is. Asylum is based on fear of persecution. So there's a few things that you are required to show. You have to show first that you have suffered past persecution in your home country. Now, persecution is a type of harm that could be physical or it could be psychological. It's got to be excessive. It usually has to be had to have been carried out on more than one isolated incident, and it has to be based on an immutable characteristic that you have that offends the person who is persecuting you. So what happens is you have to show that you have suffered past persecution in your home country, and that persecution is on account of a protected group. Now, there's two actual sort of levels, I should say, to the persecution requirement. So if you cannot show that you have suffered past persecution, you have to show that you have what is called a well-founded fear of future persecution in your country. That means that you are afraid that if you do go back to your country, that you will be persecuted. That fear has to be well-founded. What that means is that the fear has to be both subjective, meaning that you actually credibly are afraid that you will be persecuted if you went back to your country, and that the fear is objectively reasonable. That means that based on the country conditions in your country, it makes sense, it is reasonable that you would be afraid of persecution. So it's got two elements to it that you have to prove. Now, if you do show past persecution in your country, then you get what is referred to as a rebuttable presumption of future persecution. That means it is presumed that you will be persecuted in the future if you show that you have been persecuted in the past. And what rebuttable means, it means that you are presumed to have a fear of persecution in the future, but the government or the Department of Homeland Security can rebut that presumption by showing that there are now changed country conditions that no longer give rise to this fear of persecution. Now, the persecution has to be on account of a protected group. There are 5 essential protected groups that are recognized in asylum. They are race, religion, national origin, membership in a particular social group, and political opinion. Now, that means that you have to show that if you are to be persecuted in your country, that it would be on account of one of these protected groups. Now, the four of those protected groups are pretty clear in their meaning. That means race is pretty clear, religion is pretty clear, national origin is pretty clear, and political opinion is pretty clear. The one protected group that has always been subject to interpretation is this last one that is called particular social group. Courts have continued to try to interpret what this actual protected group means, but essentially it has to involve a group that has members that have immutable characteristics that they cannot change. Those can be either inherent physical characteristics, or they can be shared past experiences in certain circumstances. Sometimes a family can be a particular social group. Sometimes shared past experience could be like if you were an officer in the military, for example, that could be a particular social group. And that social group has to be socially distinct, meaning that it is distinct in society, that society recognizes that group as having these special characteristics. And it has to have particularity. That means it cannot be overbroad. So, for example, if you say, for example, business owners, a lot of times that has been rejected as a particular social group because it's overbroad, because business owners can include a huge segment of the population. So that's why that's been sort of rejected. But essentially, you have to show that you would be persecuted, or that you are afraid that you would be persecuted in your home country on account of one of the 5 protected groups, and that the persecution has to be carried out by the government or one of its agents, or a group that the government is either unable or unwilling to control. So that means sometimes if there's a powerful militia group that the government can't control, sometimes we make the argument that, for example, gangs in Central America, the governments have repeatedly failed at, have proven that they have failed at protecting people from them. So sometimes you can make those arguments. Those are the essential elements that you have to prove for asylum.
Thank you so much, Attorney Noor. Don't forget that the phone number is 216-279-3984, 216-279-3984, and you can talk to one of the attorneys in the law firm of the attorney Margaret W. Wong. And actually, we have another question related to that. It says, I am gay, I am from Guatemala, I am 21 years old. Can I apply for asylum because I am gay? I was victim of bullying for several years, and I have been in the United States for 4 years.
Okay, so it's possible that you would qualify. Generally, sexual orientation has been recognized as a particular social group by the courts in the United States for asylum purposes. Now, you have to show, as I said, that even if you show that you are of a certain sexual orientation, you still have to show a nexus. What a nexus means is that if somebody is to harm you in your country, that they would be harming you on account of that particular social group, on account of the fact that you are of a particular sexual orientation. So that's important. Why is it important? Because I can show that I'm a member of a particular social group, and that may be accepted. But let's say, for example, I have a private dispute with another person, and that person might harm me because of that private dispute. Then just because I happen to be of a certain sexual orientation doesn't necessarily mean that that person will be harming me on account of that sexual orientation. But again, if you can show that you would be harmed on that account, yes, you would qualify. Now, the one thing is, you said that you've been in the United States for 4 years. Normally, in order to qualify for asylum, you have to file your application within 1 year of entering the United States. If you don't file the application within 1 year, then you may not be eligible for asylum unless you show that you fall under one of the exceptions to the 1 year filing requirement. So exceptions can be either exceptional circumstances that you underwent. Sometimes that might include, psychological trauma that prevented you from really being able to go out there and being diligent in filing your application. Sometimes it's specific circumstances you had that physically prevented you from filing. Sometimes it could be that you hired an attorney to file the application and they failed to do so. If you show that, you can still qualify for an exception to the 1 year filing requirement. The other is changed country conditions. So let's say you come to the US and you enter and you've been here for years, and then all of a sudden there's a change in your country of origin. Say that there's a political coup or something like that. And then that gives rise to a situation that now has given you a well-founded fear of returning. Then again, that would be an exception. So you can file your application after the 1 year in those situations. Another example of that is changed personal circumstances related to changed country conditions. So for example, let's say you're in the US, you've been here for several years, but now members of your family have been targeted in your country for whatever reason. Of course, it has to be on account of a protected group, but let's say they've been targeted. So now you have a fear of returning. So that's an exception to the 1 year filing requirement. However, if you don't fall under one of the exceptions and you fail to file within 1 year, you generally will not be able to qualify for asylum. However, when you go to immigration court, you can qualify for an alternate form of relief that's called withholding of removal. Now, for withholding of removal, the standard is a little bit different. Instead of showing that you have a well-founded fear of future persecution in your country, you have to show that if you do return to your country, that you will more likely than not be persecuted in your country. And the other thing about withholding of removal is that it offers you the ability to stay in the United States until circumstances change in your country, but it doesn't ultimately give you any sort of legal status in the US. That's the difference. Asylum ultimately gets you a lawful permanent residence, whereas withholding of removal just allows you to stay, allows you to get a work permit, but you will never actually get any legal status in the US.
Thank you so much, Attorney Noor, for this answer. And don't forget, the phone number is 216-279-3984, 216-279-3984. The law office of Margaret W. Wong and Associates have 7 offices across the country in Atlanta, Chicago, Cleveland, Columbus, Nashville, New York, and Raleigh, North Carolina. And the phone number is just one, 216-279-3984, 216-279-3984 is the phone number that you need to call in order to talk to one of the attorneys in the law firm. 216-279-3984, 279-3984. The next question we have here is very interesting because this person says, I've heard that if I am in the United States for over 10 years, I can qualify for documents. Can you please tell me a little bit more? Thank you.
The actual form of relief that you're referring to is called cancellation of removal. Now, for cancellation of removal, you have to show that you've been living in the US for at least 10 years. But there's additional things that you have to show also. The one thing just to keep in mind is that you can only file cancellation of removal in immigration court. That means you have to be placed in removal proceedings in immigration court in order to be able to file that application. But if you are placed in removal proceedings and you have been in the US for 10 years, you may qualify for cancellation of removal. Now, in order to succeed in an application for cancellation of removal, there's a few things you have to establish. Now, one, as I said, is that you have to establish that you've been living in the United States for at least 10 years prior to being placed in removal proceedings or prior to filing your application. You also have to show that during that time period, during the 10 years, you were a person of good moral character. And then you also have to show that you have what is called a qualifying relative. That means you have either a spouse, a parent, or a child under 21 years of age who is either a lawful permanent resident or a US citizen. Now, the final thing you have to prove is that whoever your qualifying relative is, either your parent, your spouse, or your child or children, that person or persons would suffer what is called exceptional and extremely unusual hardship if you were forced to return to your country. Now, that standard of hardship is actually extremely high. It's the highest possible standard of hardship. You have to show something that is substantially beyond what would normally be accepted in a situation where somebody gets deported. Of course, people are going to suffer hardship. Family members are going to suffer hardship if you have to be deported to your country, whether it is because of family separation or whether it is because you have to relocate to your country. But what this application requires is that you show some hardship that is substantially beyond what would normally be expected. For example, we get a lot of cases where somebody has a child with either Down syndrome or someone has a relative that has a serious illness like cancer or something that requires regular medical attention. It doesn't have to be only medical. It can be, what is called cumulative hardship. That means when you look at all the possible hardships that all your family members would suffer, cumulatively in the aggregate, they could rise to that level of exceptional hardship or exceptional and extremely unusual hardship. So it is a difficult standard to prove. Theoretically, yes, you could qualify for cancellation of removal, but to win a cancellation of removal case is not that easy. You have to actually meet that level of hardship. And also you have to prove it with documentary evidence and with testimonies. That's why it's really important to have an attorney that knows how to file these applications, because sometimes even if you actually do have the hardship, but it's not filed properly, you could lose the case. So that's another important aspect of it, to have an attorney that knows how to file it, to establish and build that hardship in order to succeed in that application.
Thank you so much, Attorney Chamas. Don't forget that you can call. The phone number is 216-279-3984. 216-279-3984 is the phone number that you need to call in order to talk to one of the attorneys in the law firm of Margaret W. Wong and Associates, and they will help you out. Only calling the phone number is 216-279-3984. You can actually write your question right here on this live show, and the attorney Noor Chamas is going to answer your questions. We have the question of Luis Bautista, and he says, I have DACA and I would like to apply for VAWA. What should I do to keep DACA? Or I have 2 deportation for false claims to citizenship.
Okay, so if you have false claim, unfortunately, having a false claim to citizenship is almost like a death sentence in immigration. It's very hard to overcome that. It depends on when it happened. There could be a waiver available, but after 1996, there really is no waiver available for it. If for VAWA anything, so for VAWA, again, you have to show that you were a victim of abuse or extreme cruelty by a spouse who was a U.S. citizen or a lawful permanent resident. But you still have to qualify and be eligible under the admissibility rules in the United States. So if you are inadmissible for whatever reason, then you would not qualify to adjust your status under VAWA, unless you show that whatever the inadmissibility that issue that occurred was actually a direct result of the abuse that you had suffered, that you were forced to engage in that activity because of the abuse. But in this case, I'm not sure what the actual facts of the case is, but generally speaking, if you have false claim to U.S. citizenship, it'll be very difficult for you to adjust status. It's one of the most severely punished, I guess, violations in U.S. immigration law.
Thank you so much, Attorney Noor. Don't forget, the phone number is 216-279-3984, 216-279-3984. Next question we have is, I have an EU visa approved, waiting for my green card process. My question is, can I travel to my country using my EU visa while I wait for my green card?
What you can do is you can actually get an advanced parole document because you have a EU visa. And it's possible that you could travel to your country and come back. I wouldn't recommend that you travel without an advanced parole document. And I don't know how long you've had a EU visa now, but if you're waiting for your green card process, I'm not sure if you mean that you're waiting to become eligible to file for a green card, or whether you filed for your green card and just waiting for it to be processed. Now, if you're waiting for your green card to be processed, you can also easily get an advanced parole document if you have to travel. But honestly speaking, travel documents right now are taking a long time to be issued or approved. So you may very well have your green card approved before you even get an advanced parole document. However, if you have not yet filed for your green card, generally you could qualify to file for a green card 3 years after having EU non-immigrant status, so after having your EU visa. I'm not sure where you are right now, but if you have a green card application pending, then you can try filing for an advanced parole document if you really want to travel, but just based on what we're seeing now in terms of processing times, I mean, it may be moot because you may actually get your green card approved before you even get a travel document.
Thank you so much, Attorney Noor. Don't forget, the phone number is 216-279-3984, 216-279-3984. 7 offices across the country in the city of Nashville that I am today. Atlanta, Chicago, Cleveland, Columbus, Nashville, New York, and Raleigh, North Carolina. And the phone number is just one, 216-279-3984, 216-279-3984 is the phone number that you need to call to talk to one of the attorneys to set your appointment in the city that the attorney Margaret W. Wong is going to be visiting. She's actually today in Chicago. I am in Nashville, and the attorney Noor is in Cleveland. So we are all across the country today. Well, the next question we have is, I am from Haiti, and I was allowed into the country, entered in 2022. I missed my first court date. Is that too bad for my case?
Well, if you missed, so it depends. I mean, I'm not sure what the outcome was, but normally if you miss a first court date, you can, or any court date actually, you can be ordered removed in your absence by the immigration judge. I'm not sure if that's the situation in your case. However, if you were ordered removed, now Haiti right now is under TPS status. So that means you can file, and I'm not sure if you've already filed it, but you can file for temporary protected status if you are from Haiti. And if you do file for temporary protected status, you are actually then deemed not removable from the United States because you are protected. Now, in that situation, you can also potentially file to reopen your case with the immigration court and ultimately terminate it so that you don't have to worry about removal proceedings anymore. You may also be able to reopen your case even without the TPS if the reason that you missed your court date was due to exceptional circumstances. I would have to learn more about your specific facts, but it's very possible that you can still revive your case and you can still proceed with whatever application you want to apply if you have a good reason why you missed your first court date. Also, if you haven't done so already, I would strongly recommend that you file for TPS, because that will protect you from removal and also could get you to reopen and terminate your immigration court case.
Thank you so much, attorney. Do you have the date for like the deadline for people from Haiti coming on or able to apply for TPS?
It was renewed, and I can't remember honestly. I have to look it up. It was sometime in 2022. That's the date. So it's been adjusted. I'll have to look just to make sure.
Yeah, because it's been renewed and the motivations have been renewed as well. Because one of the first one was because of the earthquake in 2010,
Right.
but then the hurricanes that passed over Haiti in the last few years.
And
Haiti
it's also
is struggling a lot.
right, and also because of the political upheaval in the country. There's a lot of violence right now in the country. So
Yeah.
so it was redesignated as a TPS country, and I believe it was sometime in late 2022. I'd have to look at the date. I can't remember off the top of my head right now, but I do believe that that person would qualify for
That's
TPS,
perfect.
and I would strongly recommend that they apply for it.
That's perfect. We have one more question, and I actually think that we have only time for one more. And this person says, I entered on a B1, B2 visa in July. I will be 10 years in the United States. I have two kids born in the US. Is it recommended for me to file asylum now? I am from Colombia.
So as I said before, in order to qualify for asylum, you have to file within 1 year of entering the United States, unless you fall under one of the exceptions that I mentioned earlier. So if you do fall under one of the exceptions, then yes, you can file, and you would just have to establish why you didn't file within 1 year, and you have to have that good reason why. Now, if you do file for asylum, so you would file it with the Immigration Service, because this is what is called an affirmative filing. You're filing it with the service, and you're asking for protection. Now, let's say the service does not approve your asylum application, or maybe finds that you don't have a good reason why you didn't file within 1 year, or denies it because they don't find that you have a well-founded fear of persecution in Colombia. Then what will happen is actually the service will not deny your asylum application. They will simply refer it to the immigration court. So you will be placed in removal proceedings, and you will have another opportunity to present your case before an immigration judge. However, once you do get to immigration court, then you are eligible to file for whatever relief you qualify for. And if you've been here for over 10 years and you have 2 US citizen children, then you probably would qualify for cancellation of removal. But again, keep in mind that even if you do qualify for cancellation of removal, you still have to meet that burden, that standard of hardship that I mentioned earlier, that is really difficult. So just qualifying for cancellation of removal doesn't necessarily mean you're going to win the case. You still have to show that your children would suffer exceptional and extremely unusual hardship if you had to return to Colombia.
Okay, thank you very much, Attorney Noor. And our time is up for today. But thank you so much for your time, for every explanation of the questions and the answers that you just gave to all the people that
Thank you very much.
joined us today. Thank you so much, and looking forward to see you soon.
Thank you. I appreciate it.
Thank you so much. And don't
Have a good
forget that the law firm of the attorney Margaret W. Wong has over 15 attorneys that are working in the law firm, helping you, and over 60 people working for you to get an immigration relief. So don't forget, the phone number is 216-279-3984, 216-279-3984, the law office of Margaret W. Wong and Associates. See you next time, and thank you so much.